This is Dr. Della Welch again, talking more about contract law, and today we look at how contracts are terminated. And the mnemonic or memory device that we will be studying today is RAM, R-A-M, RAN, R-A-N. The R is for release. That's where you agree that you will sign a release and release the other person of liability. And one thing that's careful when you sign a release, sometime if you're in an auto accident and you know the blue book on the value of the car and the car is totaled, you can release just the property damage. But be very careful if you sign a release for personal injuries, because if you sign the release, it's very hard to get around a release and you've pretty well terminated your rights. A is for account stated. This often happens in the accounting area when there's a dispute about how much is owed to the creditor, and you agree on a certain amount, and that becomes account stated, and that is the amount that when paid will discharge the debt. M is for modification. You may agree to modify the terms of an agreement. You usually have a prior agreement, and you agree to modify that agreement. If it is an agreement that requires a signed writing, such as under the statute of frauds, then that modification must be in writing. But writing is always a good idea. It's very important to have a writing. R is rescission. That's where you're unwinding a transaction. And that can be due to fraud, or it can be due to mutual mistake. So we did R for release, A for account stated, M for modification. Now we did the first R for RAN, which is rescission. A is accord and satisfaction. An accord is an agreement to compromise an existing obligation which has become the subject of a good faith dispute. Satisfaction is the acceptance by one party to a contract of the agreed compromise or accord. Let me give you an example. Suppose I have a toothache and I go to the dentist, and the dentist tells me that he's going to have to do some dental work and then replace the tooth with a crown. And I honestly think that he said it would be $550 for the crown, but the drill was buzzing and I didn't hear quite well. And then later he sends me a bill for $600. Well, we have a good faith dispute. And he says, oh, I'm a busy dentist. And I say, well, I'm a busy lawyer. And so we said, why don't we come in the middle, $575. And when I pay that $575, that's the satisfaction. So the accord was our agreement to settle the bill for $575, and when I pay that amount, that is the satisfaction. Sometimes this is used when you have a good faith dispute on refunding a security deposit on property, and the landlord will put on the check in complete and total satisfaction of dispute on rental agreement and put the date. And that raises issues of, is that when you cash it, a satisfaction? So we have rescission, and then we had A, accord and satisfaction. Now we're looking at novation. A novation is a new contract. I always say new contract is like a nova, that is in effect an immediate discharge of a pre-existing contractual duty, which creates a new duty in its place. It requires the replacement of one of the previous contracting parties with a new party. Let's say that A and B are neighbors, and they get tired of looking at each other's junk, and they don't have a fence. So they say, let's go and purchase a fence, and the fence is going to be $2,000, and we will pay $100 a month until each of us, our one half or $1,000, is paid off. And then let's say a month later, we have C come along and buy B's property because B went to war or went to Saudi Arabia or something. And so all parties agree that B will be discharged and C will be in his place. So remember the mnemonic for termination of a contract. R is release, A is account stated, M is modification, R is rescission, and that's usually due to fraud or mutual mistake. And then remember the A for accord and satisfaction. And then N is for the novation. So that's how we discharge contractual duties. So then our next area of law, we will look at damages. There are various types of damages in a contract area. One thing is someone wants the expectation or the benefit of the bargain damages. So they want compensatory damages to give them the benefit of the bargain. Liquidated damages, that's where the parties, it's usually in a real estate deal, agree in advance that if there's a breach, they agree that this $500 or $1,000 will be the damages. So if you don't go through and buy the home, you may lose the $1,000. You can always argue that it's a penalty, penalty, and the law abhors a penalty. And sometimes you can go into small claims court and get that back. There's also nominal damages. That's damages of $1. That simply declares a winner. Attorneys don't like that very much because that's like 34 cents, and that's not a lot of damages for attorneys.